The Law on Special Education by Alison Karpinski. The Education of All Handicapped Children, passed in 1975, and entitles all children to a free and appropriate public education in the least restrictive environment. Individuals with Disabilities Education Act, or IDEA, provides government services for those with disabilities in the field of education. However, the child must fit certain criteria determined by the government. Section 504, Civil Rights Act, is less restrictive and was passed to help those who didn't fall under IDEA. 504 was designed to prevent discrimination towards people with disabilities and requires a plan set by individuals in the school district. A student who qualifies for IDEA also qualifies for 504, but does not work the other way around. Lastly, No Child Left Behind was passed in an attempt to raise test scores. It requires schools to annually test grades 3 through 8, and government funding can be revoked based on the school's progress. Schools must also publish an annual report for public viewing. Parents are to be involved at every stage in the evaluation and planning process and must be kept informed of their child's progress. When parents and teachers are working together cooperatively, better results become apparent. It is a legal requirement that parents be given a copy of their rights. To sum up the rights parents have, they are able to request to see their child's records at any time, request new evaluations, refuse services, and request fair hearings if any disputes arise. IDEA was designed specifically for school-age children with disabilities in the educational setting for those who qualify. It provides additional funds for students. Parent consent is also required for any evaluations. Section 504, however, is a civil rights law set to protect the rights of individuals with handicaps and programs that receive federal funding. It is less restrictive than IDEA, allowing more students to qualify for it, but it does not provide any additional funding and only requires a notice to the parent, as it does not provide for independent evaluation. Both laws, however, dictate that there should be thorough documentation and allow hearings for the students. Parents can find information on how to advocate for their child the most quickly online through the Learning Disabilities Association. Reading Rockets also provides videos parents can watch online that help spell out the advocacy process. Rights Law also provides seminars and offers many books explaining the rights the children and parents have. Some rights students have are to receive due process if she gets in trouble at school. The student shall know the charges, be heard in defense of self, and has the right to review all documents that support the charges, be treated at all times with respect and courtesy by all members of the school staff, receive a prompt hearing if he is suspended or faces expulsion or involuntarily transfer, expect a safe learning environment, receive a free and appropriate public education, and be provided accommodations for their learning disabilities. If students are disrespectful, it is best to send the student to another office or room to cool down for the remainder of the lesson or period. After they've cooled off, you can give them follow-up instruction explaining they can apologize for their actions and behave in the same manner again, or return to class, or they can have a parent contacted. These encounters do need to be recorded into a discipline log as well. However, if a student assaults you, you must report it to the police. You can then decide if you want the student arrested or prosecuted. Teachers also have the right to work in a safe environment, to be treated respectfully by their students, have a right to be able to teach, have an obligation to notify parents before beginning the evaluation process to set up an IEP, have an obligation to follow the guidelines set forth in the IEP, and teachers should realize that parents have the right by law to access and have copies of anything teachers add to a student's file. Whenever an IEP is written, it is necessary to consider the student's social, emotional, and behavioral needs. IEP should be designed to help each individual student work on these areas they have the most deficits in. Failure to properly process an IEP or failure to help a student reach their set goals can result in fines for the teacher responsible for the student or even the district as a whole. If a student has difficulties following school rules, the school psychologist should be advised to evaluate the child's behavioral needs. A meeting should then be scheduled with the parent for the purpose of writing a behavioral intervention plan. Once a BIP or BIP is signed by a parent, each person who is involved in the plan should receive a copy of it. It is a legally binding contract and it must be followed up on. Many lawmakers felt that students with learning disabilities were being unfairly discriminated towards due to their behavioral issues related to their disabilities, which is arguably denying those students of their free and appropriate public education. Before a school can suspend a student for an 11th day, the IEP team must meet and review the student's BIP and assess if it is still appropriate or not to write them a new one. The due process officers look at all of the following when assessing each case. Were teachers actually working with the student on behavioral goals? When the student was referred to the principal for action, what action was taken? Were the nature and severity of the offense considered before suspension was invoked? And would another alternative have been more appropriate? These are all reasons why it is critical teachers keep documentation logs. If problems continue to happen, a change of school may be the best option for the student. When expulsion is being considered, however, a pre-expulsion IEP meeting must be held to discuss if the student is properly placed, that all FAPE work is up to date, and to see if there is a link between the behavior and the disability. This decision requires a functional behavioral assessment, or FBA, by a specially trained team. If a student's behavior is very serious, however, such as drug or weapon possession, school districts can place a student with a disability in an interim alternative education setting for up to 45 days without parent consent. This 45-day setting can also be extended by court order if needed.